Start. Para. It appears that a copy of the circular letter was sent by Law Minister to the Chief Justice of each High Court, and the Chief Minister of each state also forwarded a copy of the circular letter to the Chief Justice of the High Court of his state. We do not know what the Chief Justices of the various High Courts did on receipt of a copy of the circular letter from the Law Minister and from the Chief Ministers of their respective states, but presumably each Chief Justice sent a copy of the circular letter to the additional judges in his court with a request to do the needful in view of what was stated in the circular letter. The Chief Justice of Bombay High Court in any event addressed such a communication to each of the additional judges in his court. We do not know what was the response of the additional judges in Bombay to the circular letter, but the record shows that out of a total number of additional judges in the country, quite a few additional judges gave their consent to be appointed outside their High Court. The petitioners and other advocates practicing on the original as well as appellate side of the High Court of Bombay, however, took the view that the circular letter was a direct attack on the independence of the judiciary, which is a basic feature of the Constitution, and hence the Advocates Association of Western India, which represents advocates practicing on the appellate side, the Bombay Bar Association, which represents advocates practicing on the original side, and the Managing Committee of the Bombay Incorporated Law Society, which represents solicitors practicing in the High Court of Bombay, passed resolutions condemning the circular letter as subversive of judicial independence and asking the Government of India to withdraw the circular letter, since the circular letter was not withdrawn by the Law Minister. The petitioners filed the present writ petition in the High Court of Bombay, challenging the constitutional validity of the circular letter and seeking a declaration that if consent has been given by any additional judge or by any person whose name has been or is to be submitted for appointment as a judge consequent on or arising from the circular letter, it should be held to be null and void. There were several grounds on which the constitutional validity of the circular letter was challenged, but it is not necessary to set them out at the present stage, because we shall have occasion to refer to them in detail when parties. The petitioner impleaded the Law Minister as respondent number 1, the Union of India as respondent number 2, and 10 additional judges of the Bombay High Court as respondents numbers 3 to 12. The writ petition was filed on 20th April 1981, and immediately after filing it, the petitioners applied to the learned single judge sitting on the original side of the Bombay High Court for admission of the writ petition and interim relief. The admission of the writ petition as also the grant of interim relief were opposed on behalf of respondent numbers 1 and 2, but the learned single judge admitted the writ petition and issued a rule and granted interim relief in terms of prayer (E) of the writ petition. The effect of granting the interim relief was that respondent numbers 1 and 2 were restrained from further implementing the circular letter and acting in any manner upon the consent, if any, obtained from any person following on or arising from the circular letter. Respondents numbers 1 and 2 thereupon preferred an appeal to a division bench of the Bombay High Court, under clause 15 of the letter's patent, but the appeal was dismissed by the division bench on 24th April 1981. The division bench fixed the hearing of the writ petition before the learned single judge hearing writ petitions on 25th June 1981 and also gave directions for tiling of affidavits by the parties, respondent number 1 and 2 being aggrieved by the order made by the division bench dismissing their appeal, made an application to this court on 8th May 1981 for taking up their special leave petition directed against the order of the division bench on the same day, but this court refused to take up the special leave petition for hearing on that day and directed that it may come up for hearing in due course. Respondents numbers 1 and 2 in the meanwhile file transfer petition number 24 of 1981 for transfer of the writ petition from the Bombay High Court to this court under Article 139A of the Constitution, and ultimately by an order dated 9th June 1981, the vacation judge directed that the writ petition be withdrawn from the Bombay High Court to this court, and he also gave directions for filing of affidavits and written briefs. Stop.